Correcting misinformation about the Reid Technique. My name is Joseph Buckley, president of John Reid and Associates. I'll be presenting this material for you in 3 parts. Critics, reporters, academicians, defense attorneys often make false and erroneous statements when describing the Reid Technique process. In this presentation, we'll list their criticisms and our responses. Let me first of all set a foundation. The core elements of the Reid Technique are based on and have utilized science-based methodology for over 7 decades. In their 2016 report, quote, Interrogation, a review of the science, high-value detainee interrogation group, September 2016, quote, the high-value detainee group, which was established by President Obama, with the responsibility of researching the most effective interviewing and interrogation processes available and what should be the guidelines to formulate those processes. In their article, they describe science-based methodology as including the following elements: the development of cooperation via rapport and trust, the elicitation of information using productive questioning to enhance a subject's recollection, the use of strategic questioning and assessment of verbal or story-based cues to evaluate credibility. The strategic withholding of evidence is a way to identify statement evidence inconsistencies and resolve a subject's responses to discrepancies. This description of science-based methodology from the high-value detainee group describes the Reid Technique process. Given this brief background, here are several false statements regarding the Reid Technique interview process. False statement: the Reid Technique is an accusatory, confrontational process. The Reid Technique always begins with a non-confrontational, non-accusatory investigative interview. Throughout the interview process, the investigator should maintain a neutral, objective, non-judgmental fact-finder approach. No accusations of guilt should be made during the interview process. The interview should begin with casual conversation, biographical information, what the individual does for a living, etc. Maybe a recent news event, sporting event, etc. The whole purpose of which is to acclimate the subject to the interview process, develop the subject's behavioral baseline, their normal verbal, nonverbal behaviors, and to develop rapport with the subject. The investigator should use open-ended questions in the interview to develop the subject's statement, alibi, story, version of events, or explanation of what occurred. Can you tell me what happened? Can you tell me what occurred when you left the building at 4 in the afternoon? Can you tell me everything the supervisor said to you that was upsetting? Some kind of open-ended question that invites the subject to tell their story. During the interview, the investigator should attempt to resolve any inconsistencies or contradictions that may have surfaced from interviewing other individuals who were part of this investigation. And if the subject offers an alibi for the period in question, every effort should be made to substantiate that alibi. We encourage investigators to follow the 80-20 rule. During the interview, the subject should do 80% of the talking. The investigator should do 20%. We should ask open-ended questions that invites the subject to tell us their story, and we should be listening to their story without interruption. And then after they're completed, we can ask clarification questions. Another false statement about the Reid process is that Reid investigators make their decision on a subject's guilt or innocence based on how they answer behavior-provoking questions. The investigative questions are the core of the interview process. The who, what, when, where, why, how are the core elements of the investigative process, not the behavior-provoking questions. The most important element in evaluating a suspect's potential culpability in committing the crime or the act of wrongdoing that is under investigation is not their behavioral responses, but the content of their statement compared to the case, facts, and evidence. The essential element to evaluate during an investigative interview is whether or not the case, facts, and evidence support and lend credibility to the subject's statement or story, or do they contradict what the subject is telling us happened. A critical investigative rule for all interviewers is that the investigator should not tell the subject what they know about the case, but evaluate whether or not the subject statement is consistent with what is known based on the case facts and evidence, or whether the case facts and evidence contradict what the subject has stated. Consider the following example. John was found dead in his home on a Saturday night. He had been shot in the head. He was found in the basement. John was a real estate agent and worked out of his home real estate office, and he had several colleagues who occasionally also worked out of his home office. So as part of the investigation, we interviewed John's colleagues, one of whom we'll call Dennis. When Dennis was asked when was the last time you had been over to John's house, either on a social occasion or to work out of the real estate office, he said, gee, it's been quite a while. I'd say at least a month, maybe even 5 or 6 weeks. Unbeknownst to Dennis, after the murder, when the police canvassed the neighborhood, they found a lady who kind of lived catty-corner across from John, who that Saturday morning, the day of the murder, was filming her kids playing soccer in the backyard. And you could see in the background somebody going up to John's house at about 10 a.m. that particular morning, the morning of the murder. And when you enhance the film and take a closer look, it turned out to be Dennis, the person who told us he hadn't been to John's for at least 4 weeks, maybe even 5 or 6. The fact that Dennis lied to us about when he had most recently been over to John's house was obviously very significant, more so than any possible behavioral observation or answer to any behavior-provoking question. So the key issue for the investigative interview is, does the subject's story, is that supported by the case facts and evidence, or do the case facts and evidence actually contradict what he's trying to tell us? Another false statement. The Reid technique is based on the faulty premise that investigators can determine the subject's truthfulness or deception based on their verbal and nonverbal behaviors during the interview. During the course of the interview, we teach investigators to observe the subject's verbal and nonverbal behaviors as a guide for interview questions. It's important to remember there's no behavior unique to truth or deception. Behavior has to be evaluated in context against the subject's normal behavioral pattern. A subject's verbal and nonverbal behaviors are not a substitute for evidence, but they can help us identify when a subject may be less than candid during the interview, prompting us to ask an additional follow-up question, which may in turn lead to the discovery of additional information, incriminating facts, or possibly even evidence. It's critical to establish the subject's normal behavioral pattern, baseline, and then look for changes from that norm or baseline. Consider the following example. During the interview, your subject exhibits the following behaviors. They're not listening to us, fidgeting, tapping on the table, squirming in the chair, excessive talking, blurting out answers before the question's even completed, etc. Now, without having established a normal behavioral pattern or baseline, we don't know what we have. We may conclude that the subject seems extremely nervous, in fact, so nervous he might be the one who's the guilty party. However, these same behaviors can be exhibited by individuals diagnosed with ADHD. So if we don't have the subject's normal behavioral pattern, by talking to them early on in the interview about what they do for a living, if they go to school, where do they go to school, what classes are they taking, something about the recent news event, the storm, the big game on Sunday, etc. If we don't have a behavioral baseline by which we can compare their behavior to, we don't know what we have. And so that's really critically important. As we say on the last bullet, it's critically important to establish the subject's normal behavioral pattern so we can make a more reasonable evaluation of the behavior they displayed during the interview. In the Reid technique, we teach that there are several rules that the investigators should follow in the evaluation of a subject's behavior. Number one, establish the subject's normal behavioral pattern / baseline and then look for changes from that norm. Secondly, look at all behavioral responses across the 3 channels of communication: verbal, paralinguistic, and nonverbal. Read behavioral clusters, the overall behavioral pattern, not just one thing they do or say. Consider timing and consistency for all nonverbal responses. Always evaluate behavior symptoms in conjunction with your case, facts, and evidence. And always consider the potential impact of a number of different factors, such as the subject's mental capacity, their psychological stability, maturity, culture, and their physical well-being at the time of the interview, all of which can affect their behavior. If these rules that we outline for assessing a subject's behavioral responses are followed, a subject's verbal and nonverbal behaviors can help us in the assessment of their credibility. Special note to keep in mind: almost without exception, these different rules we've just given you, the assessment rules, were not followed by any of the research studies used by researchers to try to evaluate whether or not verbal and nonverbal behavior can be helpful in determining a subject's credibility. They didn't follow any of these rules. For example, in one study they had they had several different inmates on camera talking about crimes that they committed. They talked about two different crimes they committed. One was truthful, a crime they did commit. One was false, a crime they did not commit, although they just tried to describe it as though they did. And the reviewers were asked to determine which was the true crime, which was the false crime. Now, they saw the subject's monologue describing the crime. There were no follow-up questions to probe the details. The reviewers had no information about the subject's background. They didn't see any examples of the subject's normal behavior. So they're essentially flying blind. So it was not surprising at all that the reviewers were almost no better than chance flipping a coin 50% in trying to assess a subject's truthfulness on each of the respective crimes they allegedly committed. They didn't have any of the guidelines or rules as part of the assessment process that we teach and that are critical to an effective evaluation of a subject's behavior. But keep in mind, even though we're paying attention to behavior, the essential element to evaluate during the investigative interview is whether or not the case, facts, and evidence support and lend credibility to the subject's statement or whether or not they contradict what the subject is telling us. Part 2. Here are several false statements regarding the Reid Technique interrogation process. The goal of an interrogation is to secure a confession. The Reid Technique is a guilt presumptive process. Investigators interrogate persons whom they believe to be guilty, and they will stop at almost nothing to secure the confession. That is a statement from Dr. Richard Leo, who's a very active critic of law enforcement interrogation techniques. And in fact, he's even testified that, quote, "I think for most police and pursuant to police training, including the Reid method, a successful interrogation is where you get an incriminating statement, even if that statement is not true. If it is incriminating, then it's a successful interrogation." Our response: clearly, the suggestion from Dr. Leo that a false confession is acceptable is completely absurd. We recommend that investigators should not use the interrogation process as the initial means by which to try to assess a subject's credibility. In other words, we recommend that following the initial non-accusatory investigative interview and the appropriate investigative steps, such as, for example, verifying the subject's alibi, interrogation should only take place when the investigative information identifies that this is the probable offender. The purpose of an interrogation is to learn the truth. In most instances, this consists of the guilty person telling us what they did regarding the commission of the crime that's under investigation. And the obvious reason for this outcome is that the interrogation is usually just utilized when the investigative information points to the probable offender. However, there can be other successful outcomes. You can have a subject who discloses to the investigator, "Look, I didn't commit the crime, but I know who did. I haven't told you this, but here's what happened." And they tell us who committed the crime. Or you might have a suspect who says he didn't commit the crime, but he was lying about part of his story. He lied about his alibi because maybe he didn't want us to know where he was at that time. And so maybe that's what's causing him some concern. Or we might discover and decide, based on the investigative information and the way the subject handled the process, that I don't think this is the guy. I think we put him on a back burner and continue looking at other possible subjects. So there are a number of potential successful outcomes from a persuasion effort. Now, when you think about it, the opposite of interrogating individuals whom the investigator believes to be the offender based on the investigative information would be to interrogate all subjects, whether evidence indicated their possible involvement or not. And obviously, such a situation would be completely unacceptable. False statement. The Reid technique involves psychologically manipulative tactics such as isolating the subject from others, exaggerating the legal consequences of the subject's behavior, making promises of leniency in return for confession, creating false evidence, and conducting questioning for an exhaustively lengthy period of time. First of all, regarding the issue of privacy, it should be noted that the United States Supreme Court understands the need for interrogations to be conducted in a private setting. From one of their cases, Colomb versus Connecticut, quote, often the place of questioning will have to be a police interrogation room because it is important to assure the proper atmosphere of privacy and non-distraction if questioning is to be made productive. If the subject is not in custody, they're free to walk out whenever they want. If the subject is in custody and chooses to exercise their right to have an attorney present or to terminate the decision, we obviously have to honor that request. In a non-custodial interrogation, the investigator should not deprive the subject of the opportunity to leave the room. We should not block their access to the door. We should not have a locked door. They should be the ones sitting closest to the door, so if they want to get up and walk out, they're free to do so. During the interrogation process, the investigator should never make any promises of leniency, threats of harm, or threats of inevitable consequences. If you don't tell me you did this, I'll make sure you never see your family again. The investigator should never physically abuse the subject, and the investigator should not conduct interrogations for an excessively lengthy period of time. If the subject remains adamant in their denials at the 3 or 4 hour mark, the investigator might want to step back and reevaluate the situation. And definitely, the investigator should never fabricate or create false evidence. Another false statement made by critics of the persuasion effort is that investigators feed the subject crime details, thereby contaminating and incriminating statement that the subject may make. We teach that investigators should not reveal details of the crime, but keep them secret. So when the subject gives them to us, it's an acknowledgement of what they did. They have that personal knowledge. Details that confirm their guilt, such as where the stolen jewelry is, the murder weapon, the bloody clothes that they were wearing, how they gained access to the facility, where they started the fire in the building, etc. Things that in some cases we don't know, and in other cases we do, but we've kept secret. So when they give us that information, it confirms their involvement. Investigators should not show the subject crime scene photographs that might reveal some of the corroborating details. For example, showing the picture of a murder victim with a rope around her neck, certainly suggesting that that's how she was killed, that was what was used, as opposed to not telling the person what was used and let him later on talk about the rope, the kind of rope, where he got the rope, etc. Another false statement, the Reid technique encourages investigators to lie about the evidence in the case. The Reid policy on the use of deception during interrogations is that investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. Now, it should be understood that in 1969, the United States Supreme Court upheld the use of misrepresenting evidence of the subject. The case was Fraser versus Cupp. In that case, the Supreme Court upheld the admissibility of the defendant's confession, which in part was the result of the police falsely telling the subject his accomplice had confessed. The United States Supreme Court held that misrepresentations were relevant, but they did not make an otherwise voluntary confession inadmissible. In reaching this conclusion, the Supreme Court judged the materiality of the representations by viewing the totality of circumstances. So it's important to highlight the court's reference to an otherwise voluntary confession. The clear implication being that if the subject's rights were honored, if there were no threats of harm or inevitable consequences, if there are no promises of leniency, if the investigator followed the guidelines established by the courts, then misrepresenting evidence in and of itself will not jeopardize the admissibility of the confession. And there's a consistent consensus of this opinion by the courts that lying about evidence in an otherwise voluntary confession will not render a confession inadmissible. It is the view of the courts, however, that behaviors such as threats of harm, threats of inevitable consequences, denial of rights, promises of leniency, or other such coercive behaviors will jeopardize the admissibility of the subject's confession. In recent years, several states have enacted legislation that prohibits law enforcement investigators from lying to juveniles about the case evidence. Among those states are Illinois, Oregon, Delaware, California, Utah, Indiana, and Connecticut, and you should be sure to check your state's statutes to see if you're one of those states as well. Given current judicial and legislative trends regarding the use of deception during an interrogation, it's our policy that investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. False statement. In the Reid Technique, investigators suggest to the subject that they had a psychologically acceptable reason for committing the crime, thereby essentially suggesting they will receive a reduced punishment. This is called a minimization technique. But if they don't confess, they will face the maximum consequence. This is called maximization techniques. The core of the Reid interrogation process is what is called theme development, in which the investigator presents a moral or psychological excuse for the subject's behavior. Essentially, the interrogation theme reinforces the subject's rationalizations or justifications for committing the crime. As part of the offender's decision to commit a crime, or in the case of a spontaneous crime, following it, it's natural for the subject to try to justify or rationalize their crime in some manner. Psychologists refer to this internal process as techniques of neutralization. Neutralization theory has shown that criminals use techniques such as the denial of responsibility, denial of injury, denial of the victim, condemnation of the condemners, and appeal to a higher loyalty to neutralize their feelings of guilt or shame associated with what they did. This theory proposes that people who commit crimes often use techniques of neutralization to deflect responsibility for their actions and justify their criminal behavior. Over 7 decades ago, in the first edition of their book, Criminal Interrogation Confessions, authors John Reid and Fred Embaugh recognized this core element of human nature, that when we do something wrong, it's our natural inclination to want to shift the blame to some other person, some other circumstance, some other influencing factor, so it tends to minimize our feeling of culpability or guilt. So John Reid and Fred Embaugh developed, as part of the persuasion effort, what's called theme development, where the investigator offers the subject some kind of justification or excuse for their behavior. When we develop themes, we're appealing to the subject's pre-existing justifications, or indicating that we understand them, which in turn makes it more comfortable for them to tell us the truth about what they did. Here's another statement to consider from false confession critics. Social psychologists often describe 3 investigator errors that they suggest can lead to a false confession: misclassification, erroneously labeling an innocent person as guilty based on their demeanor and the behavior they displayed during the investigative interview; coercion, using tactics that offer reduced punishment if the subject confesses, harsher punishment if they don't, and contamination, revealing to the suspect details about the crime that only the police or the guilty person should know. The first error that leads to false confessions is called misclassification. Critics point out that the research indicates most investigators are no better than chance in evaluating a subject's behavior for indications of truthfulness or deception. Therefore, investigators oftentimes interrogate innocent people. Now, as previously mentioned, in the Reid Technique, we teach that there are a number of different rules that have to be followed to evaluate a subject's behavior symptoms. Establish their normal pattern or baseline, then look for changes from that norm. Look at the overall behavioral responses on the three channels of communication: verbal, paralinguistic, and nonverbal. Look at the overall pattern, behavioral clusters, not just one thing they do or say. Consider the timing and consistency of nonverbal responses. Always evaluate behavior in conjunction with your case, facts, and evidence. And always evaluate the potential impact of possible factors such as the subject's mental capacity, psychological stability, maturity, culture, physical well-being at the time of the interview on their behavior symptoms. And finally, researchers consistently fail to allow for the impact of the subject's story versus the case, facts, and evidence, which is oftentimes the critical element in evaluating their possible involvement in the commission of the crime. Regarding coercion, the second area that leads to false confessions, according to false confession experts, coercion involves using tactics that offer reduced punishment if the subject confesses, harsher punishment if they do not. Well, we always teach and have for decades that the investigator should never make any promises of leniency, never make any threats of harm or inevitable consequences, or physically abuse the subject in any way, and should not conduct interrogations for an excessively lengthy period of time. But as I mentioned earlier, if the subject remains adamant in his denials at the 3 or 4 hour mark, the investigator should reevaluate the situation. And the investigator should never deny the subject any of their rights, should not deny the subject the opportunity to satisfy their physical needs, and in a non-custodial interrogation should not deprive the subject of the opportunity to leave the room. Regarding contamination, the third error that leads to interrogation of innocent subjects, revealing to the suspect the details of the crime that they include in their confession, details quote-unquote only the guilty would know. Corroboration is absolutely an essential element to establish the authenticity of a subject's statement. So the investigator needs to be sure they keep various details secret to see if the subject can provide that information. When the subject acknowledges what they did, the investigator should ask open-ended questions to develop corroborating information: the location of the murder weapon or bloody clothes, how they gained entrance into the building, where the subject sold the stolen jewelry, information that only the guilty person would know. Causes of false confession. Social psychologists often try to suggest that the Reid Technique causes false confessions, but such statements are clearly not supported by evidence or even their testimony. In the case of U.S. versus Jocks, the federal court found that, quote, in his declaration and at the hearing, Professor Hirsch, who was the expert witness on false confessions in this case, explained that the primary cause of coerced compliant confessions are certain interrogation methods employed by law enforcement, including a widely used method known as the Reid Technique. The court stated that beyond his tuition, however, Professor Hirsch offered no basis for concluding that these tactics had any tendency necessarily to cause false rather than true confessions. The court went on to say that Professor Hirsch's declaration offered no other evidence of the danger of certain police interrogation tactics, and the Reid Technique in particular, except to say that the use of these tactics employed in the Reid Technique and their correlation with false confessions are extensively documented in the literature. The court pointed out that despite this broad statement, he did not provide any further explanation. In summing up his testimony, the court said that the expert testimony to the effect that the Reid technique enhanced the risk of an unreliable confession lacked any objective basis whatsoever. From the court, quote, "Although Professor Hirsch insisted there is a wealth of information about the risks of the Reid technique, he could point to none." In a December 2019 case from the Superior Court of New Jersey, the court stated that no case supports the contention that using the Reid technique renders an adult's confession inadmissible. The court pointed out that a subject will have a natural reluctance to admit commission of a crime and furnish details. Therefore, an interrogating officer may dissipate this reluctance and persuade the person to talk as long as their will is not overborne. Over the years, Johnny Reid and Associates has assisted the Innocent Project in New York on several cases as expert witnesses on proper interview and interrogation techniques, as well as the exoneration of one of their clients by obtaining a confession from the real offender. In fact, this case was detailed in the story "I Did It" in New York Magazine, and you can see the website. Several of our investigator tips that relate to interrogation issues are published on reid.com under the Resources button. A few of them are false confessions, the issues to be considered, what questions should be asked to determine the voluntariness and validity of a subject's confession, the Reid technique, science-based interviewing, responding to a false confession expert in your case. So part 3, based on our discussion, the following are the core principles and best practices of the Reid technique that we have been teaching for decades that all investigators should follow. Interrogations should only be conducted when the case investigative information indicates the subject's probable involvement in the commission of the crime. The purpose of an interrogation is to learn the truth. The investigator should conduct all interrogations following the guidelines established by the courts, the appropriate advisement of rights, the presence of a parent or guardian for a minor, etc. The investigator should not make any promises of leniency, threats of harm, or inevitable consequences, or physically abuse the subject. The investigator should not conduct interrogations for an excessively lengthy period of time. If the subject remains adamant in his denials at the 3 or 4 hour mark, the investigator should reevaluate the situation. The investigator should never deny the subject any of their rights. The investigator should not deny the subject the opportunity to satisfy their physical needs. In a non-custodial interrogation, the investigator should not deprive the subject of the opportunity to leave the room. The investigator should exercise special precautions when questioning juveniles or individuals with mental or psychological impairments, and the investigator should never manufacture evidence implicating the subject. Investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. The central focus of the persuasion process is to propose to the suspect reasons and motives that will serve to psychologically justify or excuse their behavior, not legally justify or excuse their behavior. When a subject acknowledges what they did, the investigator should ask open-ended questions to develop corroborating information. The location of the murder weapon or bloody clothes, how the subject gained entry into the building, where the subject sold the stolen jewelry, etc. Corroboration is an essential element to establish the authenticity of the subject's statement. The interview and interrogation should be recorded. The subject's confession is not the end of the investigation. The investigator should continue to develop additional details about the subject's behavior before and after the commission of the crime, and to further verify the details of his statement of involvement. Finally, all investigators should adhere to the following principles of practice. Always treat the subject with dignity and respect. Always conduct interviews and interrogations according to the guidelines established by the courts. Do not make any promises of leniency. Do not engage in any physical abuse of the subject. Do not make any threats of harm or inevitable consequences. Do not conduct interrogations for an excessively lengthy period of time. Do not deny the subject any of their rights. Do not deny the subject the opportunity to satisfy their physical needs. Exercise special caution when questioning socially immature juveniles or individuals with mental or psychological impairments. The interview and interrogation should be recorded. Thank you very much for taking time to review this information. Don't hesitate to reach out to us if you have any questions or need any clarification. Thank you again.